I already knew. On this same video right here, you're gonna hear me say it. Let me let y'all hear some of it first. Then I'm gonna show y'all what I'm talking about. Not to say, okay, we got this guy said you did this crime. None of that shit. This is just a man taking his place. What do you mean, 86 motherfuckers saying they not a crip and they all going to trial? No, stupid. When I first go to when I first get a court and you go get a rain, you y'all can understand why the questions are so specific. When you snitch in the motherfucking interrogation room. You snitch to the detective. You give them the information, and then you solidify by going on trial. That's what snitching is. You don't have any paperwork saying he was snitching. You have his paperwork when he go be in front of the judge, and the judge is sentencing him. They say, okay, you're agreeing to take this plea under these circumstances because we got your ass, and that's that. This is not about telling on nobody. This ain't about none of that. This is the procedure you go through when you take a plea deal. See, motherfuckers got to know they shit. I'm not no law professor, nigga. I just been to the joint enough times to think this shit. The fuck? Now let's check some of this shit out. What I'm talking about.
Questions about the crime and evidence during the plea colloquy.
Hold on, y'all fucked up. Let me get y'all together. Okay, here we go. Let me show y'all what I'm trying to show y'all. See, motherfucker. Okay, here we go. Listen to this. Listen to this.
The questions about the crime and evidence during the plea colloquy pleading process establish a factual basis for your guilty plea. 0. Their exact purpose. To confirm you admit facts supporting every element of the offense, e.g., did you specific act, on, date, ensuring the plea is knowing, voluntary, and not coerced, preventing later appeals claiming it was invalid or you were innocent. 1. 7. In Missouri, it's required by court rules before the judge can accept it. 0.
The judge can't even accept the shit if it's not even what you call it. Okay. So did y'all hear that and understand it? Let's make sure. Let's hear it again.
The questions about the crime and evidence during the plea colloquy pleading process establish a factual basis for your guilty plea. 0. Their exact purpose. To confirm you admit facts supporting every element of the offense, e.g., did you specific act, on, date, ensuring the plea is knowing, voluntary, and not coerced, preventing later appeals claiming it was invalid or you were innocent. 1. 7. In Missouri, it's required by court rules before the judge can accept it. 0.
So, what they saying, according to the court rules, you cannot, the judges cannot accept a plea deal without having that information in order to make sure that there is no, like they said, he wasn't coerced into doing it. None of that type of shit. You know what I'm saying? It's 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 a way of them securing. It's a way of them securing they the fact that damn, I can't even get to this shit. Okay. Okay. Mhm. Okay. So the question I got is, yeah, okay, here we go. Let's hear it. Let's hear it. Here we go, right here.
No, in cases with co-defendants, the factual basis admissions, specific crime details, one defendant makes during their plea colloquy aren't admissible.
Wait a minute, let me stop that. I had to stop that right quick because I want y'all to hear it all. Let me make sure I got this in order. Okay, let me go. Okay, we're gonna start here. Let's go. Now here we go, y'all.
Preliminary hearing. The key final steps are: plea hearing. You appear in court to formally plead guilty. The judge questions you, plea colloquy, to confirm it's voluntary. You understand charges, penalties, rights waived, e.g., trial, jury, and there's a factual basis. Agreement terms are disclosed. Judge accepts, rejects it. 6. If accepted, it binds the sentence. If rejected, you can withdraw the plea. 5. Presentence investigation. A probation officer reviews your background history. Victims may submit impact statements. 5. Sentencing hearing. Judge imposes sentence, e.g., jail, probation, fine, per agreement or law. You attorney prosecutor argue. Victim can speak. 5. Language is formal. Judge asks, how do you plead to charge? You say, guilty. Judge, do you understand this waives your trial rights? Etc. Quick and scripted to protect you.
Okay, so like I was telling y'all, this is a procedure, period, for when you accept the deal. All that shit about snitching is done. It's over with. That part is when you in this part of the court process, there is no snitching, as you see. But finish listening.
Defendants almost always plead not guilty at arraignment because it's a safe, standard first step that preserves all options, like negotiating a plea deal, reviewing evidence, or going to trial without locking in guilt prematurely. 0. 1. 5. You can always change to guilty later, but not the reverse. 5. Most haven't consulted a lawyer yet or had time for discovery, so rushing a guilty plea risks a worse outcome. 6. The 10-second speed. Arraignments are mass, scripted formalities. Judge reads charges, asks, how do you plead? Defendant or lawyer says, not guilty. And it's over, efficient for busy courts. 0.
Now, like I was trying to say, they always say not guilty first because it seems like when they say not guilty, like they want to fight it, and then go ahead and claim guilty is like giving a break. It's like a reward for it. So as we see, this is the procedures of when you plead your case. Now hold on, it's not over with. Check it out, so y'all can know. Surf is not a motherfucker snitch.
The questions about the crime and evidence during the plea colloquy pleading process establish a factual basis for your guilty plea. 0. Their exact purpose. To confirm you admit facts supporting every element of the offense, e.g., did you specific act, on, date, ensuring the plea is knowing, voluntary, and not coerced, preventing later appeals claiming it was invalid or you were innocent. 1. 7. In Missouri, it's required by court rules before the judge can accept it. 0.
So like they say, the judge can't even accept it if you don't do that. That's the process. So that way, like I said, you can't come back for an appeal. See, if you lose out in trial, you can appeal that shit. You know what I'm saying? Claim all type of shit. But if you take a plea deal, they read all this shit to you to make sure you knew what you were doing when you called yourself guilty. Now check this out.
No, in cases with co-defendants, the factual basis admissions, specific crime details, one defendant makes during their plea colloquy aren't admissible against the others at trial. They're hearsay, and under the Bruton Rule, followed in Missouri, such out-of-court statements by a non-testifying co-defendant can't be used if they implicate others, violating confrontation rights. Only usable against the speaker, unless they testify as a witness. 26. 29.
Now, Now, what did I tell y'all? I said, listen, if he in there doing that, that shit is over. You don't snitch in the court. That is the procedure of going through the shit. Now, the only time you're gonna be in court and snitching on somebody if you're taking a stand as a witness to testify. And right now, you are not. He is not in this paperwork. He is being referred to not as a CI, not as a witness, but as a defendant. Let's hear this again and make sure we got it. We don't need no mistakes. No, he did not snitch.
No, in cases with co defendants, the factual basis admissions, specific crime details, one defendant makes during their plea colloquy aren't admissible against the others at trial. They're hearsay, and under the Bruton Rule, followed in Missouri, such out of court statements by a non testifying co defendant can't be used if they implicate others, violating confrontation rights. Only usable against the speaker, unless they testify as a witness. 26. 29.
Okay, so there y'all got it, man. Ain't nobody doing no fucking faking, no fucking plan. As you clearly see, no, he did not snitch. He did not tell. It clearly says that information that this dickwad kept saying was gonna be used. It is not. Straight up, man. Shout out to my main man. Goddamn me. Shout out to my main man, motherfucking Surf, for them try to shit on my man and we know he ain't done shit. He did, motherfuckers faking. He did, as you see, that is not based on what he was doing, was talking about himself in the situation. That the shit that he was saying is only going to affect him. It's not affecting anybody else. In the situation. That's that. Straight like that, Jack. No motherfucking faking. I just had to make that straight, get that right. Yeah.